I'd like to thank the Soros Foundation Kyrgyzstan and the Coalition Against Torture of Kyrgyzstan for inviting me in my capacity as the United Nations Special Rapporteur on Torture and other cruel, inhuman, and degrading treatment or punishment to this international conference. Due to previous commitments, I regret that I am unable to attend in person, but I do welcome the opportunity you have given me to participate in this conference, considering its very worthy and important focus. In my remarks today, I will concentrate on the topic of combating torture in Central Asia and on progress and future challenges in this regard. The eradication of torture, cruel or inhuman treatment as a matter of practice, rather than merely in the realm of normative development, is a crucial endeavor. The prohibition against torture and other cruel, inhuman, or degrading treatment or punishment is a rule of customary international law that enjoys the enhanced status of being a jus cogens norm, that is, a peremptory norm of general international law applying to all states. It requires states not merely to refrain from authorizing or conniving at torture or other ill treatment, but also to suppress, prevent, and discourage such practices. States have not only the obligation to respect the prohibition, but also to ensure respect for the absolute prohibition against torture. Although the existing international legal framework provides a broad range of norms and standards designed to combat torture and to prevent and remedy acts of torture and ill treatment, this sophisticated normative framework that is in place regrettably often does not translate into a reduction in the practice of torture. In this context, it is important to recall that implementing standards into practice is a two-stage process. First, it requires a focus on substantive constitutional, legislative, and administrative reforms that need to be expedited to ensure effective criminalization of torture and the establishment of solid safeguards against ill treatment. Second, the effective realization of these safeguards in practice is the ultimate challenge and the key to the prevention of torture. In the Central Asia region, incremental progress has been made towards the elimination of torture, but much more needs to be done to bridge the gap between policy and reality, between law and practice. In 2011, I visited Kyrgyzstan at the invitation of the government with a view to assessing the situation of torture and ill treatment on the ground and to identifying measures needed to prevent it in the future. At the time, I expressed my appreciation for the invitation extended as well as for the access I was afforded to make the relevant assessment. During the course of my visit, I was impressed by the progress made by the Kyrgyzstan authorities to curb torture. On the other hand, the visit made clear that the lack of legislative safeguards to prevent torture persisted, that there were significant shortfalls in law enforcement practices, and that torture continued to occur with impunity. At the end of my visit, I made detailed recommendations to the government of Kyrgyzstan, notably calling on the government to expedite legislative reforms to ensure the absolute prohibition of torture and to establish effective safeguards in law and practice, to initiate prompt, impartial, and thorough investigations into allegations of torture and ill treatment, and, when warranted, to prosecute perpetrators without delay. I am encouraged that these recommendations have been taken seriously by the authorities and that incremental progress has continued to be made. In 2012, I engaged in a follow-up visit to Kyrgyzstan for additional consultations with state authorities and other stakeholders to examine necessary legislative and institutional reforms that were needed to implement my recommendations. I have since been encouraged by some important steps forward, such as the conclusion of a multilateral memorandum of understanding aimed to boost cooperation between state bodies, human rights organizations, and the international community in torture prevention, as well as the establishment of the Kyrgyzstan National Preventive Mechanism, which became operational in 2014. I welcome the fact that Kyrgyzstan has also declared its zero-tolerance policy for torture and ill-treatment and reaffirmed its commitment. All this progress makes Kyrgyzstan closer to the eventual eradication of torture as a matter of practice. Subsequent to my visit, the Committee Against Torture and the Human Rights Committee, while welcoming legislative and administrative measures aimed at the prevention and eradication of torture, also echoed concerns with regards to ongoing common practices of torture and ill-treatment of persons deprived of their liberty to extract confessions, particularly during the first hours of apprehension and police custody. Those bodies also expressed concern at the persistent pattern of failure to conduct prompt, impartial and full investigations into allegations of torture and to prosecute perpetrators, which drives impunity and encourages the continuation of mistreatment. And they also expressed concern at shortfalls in the definition and penalization of torture in the criminal code. The lack of implementation of basic safeguards for all persons deprived of their liberty, including failure to register all detainees immediately upon apprehension, the lack of access to a lawyer of their choice, the lack of a medical examination immediately upon their apprehension, and the lack of access to medical assistance of their choice also remain issues of concern. Additionally, harsh conditions in places of deprivation of liberty, including overcrowding, lack of hygiene, and insufficient food and drinking water, also need to be addressed. Within the region, I have also previously visited Tajikistan in my capacity as Special Rapporteur, where I once again appreciated both the invitation extended to me and the cooperation of the government of Tajikistan. While I was encouraged during the course of my visit by legislative developments in the normative framework prohibiting torture and ill-treatment, I was similarly concerned by practices identified in that country, such as pressures applied to detainees. I issued recommendations following that visit and urged the government to fully implement existing laws and practices, laws and policies for the eradication of torture and ill-treatment. I subsequently revisited Tajikistan and was satisfied with the extent to which my recommendations were being taken seriously, and with the establishment of a national plan of action for the implementation of my recommendations. However, as I have emphasized in connection with Kyrgyzstan, also with respect to Tajikistan, a gap still remains which must be bridged between policy and reality insofar as it relates to torture. I also expressed deep concern about information received related to intimidation and reprisals after my initial visit, despite a clear understanding with the government that such acts were unacceptable, and they constitute a serious threat to the work of the rapporteur and other UN human rights mechanisms. The responsiveness of countries such as Kyrgyzstan and Tajikistan to ongoing dialogue and follow-up with the special rapporteurship and with other United Nations mechanisms is an example to countries within the Central Asia region and beyond that region as well. It gives hope that through sustained efforts, effective means to investigate, document, combat, and ultimately eradicate torture can be established and implemented. Joint activities and collaboration with relevant stakeholders from civil society and international organizations, such as today's conference on the Istanbul Protocol and its implementation, are also crucial in assisting governments to meet their obligations and to bridge the gap between international norms and practice on the ground. As we embark upon this conference, I would like to take this opportunity to recall certain core systemic factors which contribute to the persistence of torture and to which a special attention ought to be devoted, while still more, of course, could be noted. It should be remembered that torture occurs because national legal frameworks are deficient and do not properly codify torture as a crime with appropriate sanctions. Torture persists because national criminal justice systems lack the essential procedural safeguards to prevent its occurrence, to effectively investigate allegations, and to bring perpetrators to justice. Torture remains entrenched because of a climate of tolerance of excessive use of force by judicial and law enforcement officials in many countries. For torture to be eradicated, instances of alleged torture must be promptly and impartially investigated, and alleged perpetrators must be prosecuted and, where appropriate, punished. This requires a comprehensive institutional capacity which ensures accountability for torture. Criminal law and procedures should allow for the investigation, prosecution, and punishment of this crime in accordance with the United Nations Convention Against Torture. This is essential for combating and preventing a culture of impunity. We must also mention the right to a remedy under international human rights law and to rehabilitation as a form of reparation, which are clearly grounded in binding international law. Every state has the obligation to ensure within its legal system that a victim of an act of torture and other ill treatment obtains redress and has an enforceable right to fair and adequate compensation and rehabilitation. More broadly, the prohibition of torture should impact and be reflected in constitutional and wider legislative structures. This requirement is given expression in the United Nations Convention Against Torture, which requires state parties to take effective legislative, administrative, judicial, or other measures to prevent acts of torture in any territory under its jurisdiction. Crucially, it is not enough for these systemic measures to be normatively reflected. They must be implemented and thoroughly actualized in practice. Under the rubric of fighting crime, countering terrorism, or implementing effective immigration policies, states have regrettably attempted to dilute cardinal principles that are necessary to prevent and suppress torture and ill treatment, or have become complicit in acts of torture. Fundamental rules have also been disregarded. The exclusionary rule, which prohibits the use of evidence or statements obtained as a result of torture and ill treatment, has been vulnerable to violation. Relevant transparency and oversight mechanisms necessary to ensure the exclusionary rule is upheld remain woefully absent in many jurisdictions, while pressure on state authorities to violate the rule is great. States must work towards the uniform and absolute application of the exclusionary rule as an extension of the peremptory prohibition of torture, which knows no exception. Ultimately, if states take their obligations under the Convention Against Torture and its optional protocol seriously and abide by their binding legal obligations, torture can easily be eradicated in today's world. Furthermore, the appalling conditions of detention in most countries of the world could be effectively addressed by implementing the body of principles for the protection of all persons under any form of detention or imprisonment. The Convention and its optional protocol contain a broad range of very specific, positive state obligations aimed at preventing and combating torture, and no further standard setting is required to combat torture. What we need is robust implementation of existing standards. Lastly, and perhaps most important for our purposes today, I must emphasize that forensic experts have a decisive role in holding perpetrators to account. As I elaborated in my 2014 report to the General Assembly on this topic, with their forensic expertise, they ensure that torture traumas, whether visible or invisible, physical or mental, are scrupulously documented before they disappear. Medical records can be instrumental in overcoming the otherwise lack of objective evidence with which survivors of torture are so commonly confronted, given that torture mostly takes place without witnesses. The work of a forensic scientist is germane to the efforts to address impunity for acts of torture, as such expert opinion forms the evidentiary basis for prosecution of allegations of torture. In this context, the Istanbul Protocol is key to the realization of effective investigation of torture and sets out internationally recognized standards for investigation and documentation of torture and ill treatment. This conference will serve as an important opportunity to exchange experiences and practices surrounding the implementation of the Istanbul Protocol and to elaborate on a plan of action for its realization and implementation. In coming together to discuss the protocol, I urge all participants to have a broad view present in their mind and in their goals for this worthy meeting, a view which supports the prevention of torture. I would also urge participants to continue the work initiated by states such as Kyrgyzstan and Tajikistan to evaluate existing legislation, mechanisms, and practices intended to foster compliance with international norms prohibiting torture and other ill treatment. I would further urge participants to consider systemic factors, such as inadequate legislative or criminal justice frameworks or other shortcomings that contribute to the proliferation of both torture and impunity for torturers. In moving forward with the ongoing and fundamental elaboration of the draft Istanbul Protocol Plan of Action, such overriding concerns must also receive due attention. I fully support the idea of a systematic approach to address the reasons why the Istanbul Protocol is not fully or adequately implemented in today's world. More specifically, I pledge my support for the plan of action that you will discuss and approve at this meeting. Without prejudice to that, I am also persuaded of the need to proceed to a review of the Istanbul Protocol in order to update it with the normative and scientific advances that have taken place in the 2 decades since the protocol was drafted. I hope many of you will join me, and hopefully my soon-to-be appointed successor in the rapporteurship, in generating a broad and participatory consultation with experts to conduct such revisions and updating of a fundamental tool for the eradication of torture as is the Istanbul Protocol. Thank you very much for your attention, and I wish you successful proceedings for the rest of this important conference.